Prior year's bills treasurer to see if the town will vote to raise and appropriate the sum of $2,702.05 to pay the following unpaid bills of fiscal year 2012 as authorized under General Laws, Chapter 44, or take any action thereon or in relation thereto. Department Treasurer, Vendor, DUI, Unemployment.
Mr. Moderator,
Mr. Hillman.
I move the town to raise and appropriate the sum of $2,702.05 to pay the following unpaid bills for the fiscal year 2012 as outlined in the warrant.
Is there any discussion? Ms. Gittner.
Thank you. I had this article put on because I've been working on this unemployment issue for 2 years now. As I've mentioned before on numerous occasions, the change to the WR1s was not an easy transition. In 2009, the state decided they wanted to separate the file for quarterly state taxes and the unemployment taxes. And so the Quest system was created for the unemployment file. Every city and town in the state had problems with this system. The former treasurer had only worked with Quest for 2 quarters before his retirement. He had many problems trying to send the file. When I took over, I also had problems sending the file. In 2011, by accident, I found some employees on the file who should not be on it. Previously, these were backed out and a check was sent in. I spent many hours trying to figure this out. I called many people at unemployment to find out how the system worked before I found the one person who also, wait a minute. So I called many people before I found the one person who had spent many hours trying to help me. Once I figured out who should and who should not be included on the report, I had to recreate the files starting with Q1 2010. Every quarter's unemployment file, check and recheck to make sure they were all correct, and then send in the new file or fix the ones that had already been sent in. This took a lot of time, and finally in Q2 of 2012, the file had been sent in correctly. Throughout this process, there has been many times when they owed us and we owed them. The final amount owed is $2,702.05, plus interest up to June 30th, 2013. I am estimating that the interest will be about $400, so I'm asking to make an amendment to this or to add to make this $3,100 to be able to pay off what is owed.
Is that $3,100 even?
Yes, I did round it off.
Okay. Is there a second? Any discussion on the amendment? There being none, all those in favor of changing the amount from $2,702.05 to $3,100, please say aye. Aye. Those opposed? The ayes have it. The amendment is agreed to. Is there any further discussion on the motion as amended? This requires a 4/5 vote. All those in favor, please say aye. Aye. Those opposed, say no. Could I just ask the ayes to stand and hold up their cards? Thank you. Could I please have the nays stand up and hold their card? 4/5 having been attained, motion is passed. Town council has informed me I can't just do what I just did. I'd have to ask for a motion from the floor to authorize the moderator to declare a 2/3 or 4/5 vote without having taken account. Been moved and seconded. Any discussion? There being none, all those in favor, please say aye. Aye. Opposed? The ayes have it, motion is agreed to. Okay, so Article 25th is passed by at least a 4/5 vote. Article 26, pay prior year's bills, Building Commissioner. To see if the town will vote to raise and appropriate the sum of $333 to pay the following unpaid bills of fiscal year 2012, as authorized under General Laws, Chapter 44, or taking action thereon or in relation thereto. Department, Building, Vendor, Eric Altonian. Description is weights and measures.
Mr. Moderator,
Ms. Livingston.
I move the town to vote to raise and appropriate the sum of $333 to pay the following unpaid bills of fiscal year 2012 as outlined in the warrant.
It's been moved and seconded to pay the sum of $330 in unpaid bills for the Building Commissioner. Is there any discussion? There being none, all those in favor, please say aye. Aye. All those opposed, say no. Okay, could I ask all the ayes please stand and hold their card up? Thank you. And may I ask all the nays to stand up and hold their card up? Thank you. 4/5 having been attained, the motion is passed. Article 27, Gas B45 compliance. To see if the town will vote to raise and appropriate the sum of $7,200 to fund actuarial costs associated with required updating of the Gas B45 disclosure requirements for post-employment benefits, or take any action thereon or in relation thereto.
Mr. Moderator,
Mr. Luca.
move the town vote to raise and appropriate the sum of $7,200 to fund actuarial costs associated with the required updating of GASB 45 and take any action thereon relation thereto.
It's been moved and seconded. Is there any discussion on the...
Mr. Moderator,
Mr. Luca.
under federal law, we have to do this every 2 years to update our tables, and this is kind of an important one since the school's left. So we'll see what the future funding is going to be.
Any further discussion? All those in favor, please say aye. Aye. All those opposed, say nay. The opinion of the moderator, the ayes have it, the motion is passed. Article 28, self-contained breathing apparatus. To see if the town will vote to raise and appropriate the sum of $9,421 as the town's matching share for a grant for the purchase of self-contained breathing apparatus, or take any action thereon or in relation thereto.
Mr. Moderator,
Ms. Connolly.
I move the town vote to raise and appropriate the sum of $9,421 as the town's matching share of a grant for the purchase of self-contained breathing apparatus.
Is it been moved and seconded? Is there any discussion on the warrant?
Mr. Moderator.
Ms. Connolly.
As outlined in the warrant, the fire chief secured a grant in the amount of $188,432, and this is the town's portion to match to enable that grant. So congratulations to the fire chief, and I hope everyone will support this.
Any further discussion? There being none, all those in favor say aye. Aye. Opposed? The ayes have it, motion is passed. Article 29, DPW Administration Garage Facilities Plan. To see if the town will vote to raise and appropriate the sum of $17,000 required to provide for the development of an independent professional facilities plan for the Department of Public Works, administrative building and garages authorized by this town meeting, or take any action thereon or in relation thereto.
Mr. Moderator,
Ms. Conley.
I move the town vote to raise and appropriate the sum of $17,000 to provide for the development of a professional facilities plan for the Department of Public Works, administrative building and garages, to be explained by Mr. Wetzel. And I'll stop there for the moment.
Second.
That's all right.
Mr. Wenzel.
Thank you. The project objective for this is to develop a master plan for the existing and future needs of the DPW and other town departments. Right now, the DPW site as DPW and wastewater treatment plant has about 160 acres. We need to look at the future space needs so that we can allocate property and not say, oh, gee, we need more garage. We probably shouldn't have put the anaerobic digester in that spot. So these are some of the future space needs we need to put in. We need additional garage facilities sometime in the future, administration space, anaerobic digester that I talked about last night to create methane gas to create energy. The police department has asked us about potential of putting a shooting range somewhere on the property. We have a yard waste compost area that we haven't formalized yet. We'd like to make that into a little more organized area that we can then allow people to come and get some composted topsoil. And also the Boy Scouts use the facility. Next slide. This is just an overview. This is an overview of the entire site. You can see where the circles are, the wastewater treatment plant, and then up on the right side where there's a white square, that's our salt shed, and the DPW office. And so you can see there's a lot of open space, but there are some other restrictions. We have power lines running through there. We have wetlands on several sides. So we need to really look at the entire plot and what can we do where. Next slide, please. This is what we currently have. I'll start in the upper left corner. There's our where we store our plows for the winter. Obviously, they're outside and it's not a real secure spot. The next center top is what we call the wood shed, and we store a lot of stuff in there. It's open to the elements in the front. The upper right is called the tank, and we store snow removal things there in the summer and mowing equipment in the winter, and it is actually an old wastewater tank. And then we have a couple other areas where we store pipe and materials. We have, I don't know if you can see the bottom middle, those are our emergency response trailers that the fire, police, and DPW use. They're not stored in an easily accessible area. If we have a snowstorm, they're difficult to get at. And then the other lower right is the old wastewater pumping station we store a lot of our hand tools in. So we have stuff kind of in all these old used buildings, and none of them are super secure or climate controlled. So we do need additional garage space. We had a couple of our snow plows stolen from the water treatment plant a couple years ago because they weren't stored in a garage. As I mentioned before, the emergency response trailers are outside. Also, I've been talking with the fire chief about they have a flooding problem, and if they want to solve the flooding problem, they have to come up with compensatory storage So there's potential for doing that on the property. We need to identify where that is. The existing highway garage doesn't have proper ventilation. There's no locker room, there's no lunch room, and there's only office space for a couple people. And then we also have some long-term capital improvements. We have to put a canopy over our gas filling station. Our salt storage shed is starting to fall apart. So what we'll do in this study is we'll look at all of these items and come up with a master plan so that as we start implementing future improvements, we'll know where they need to go and how big they need to be.
Is there any further discussion? There being none, all those in favor, please say aye. Those opposed? The ayes have it, the motion is adopted. Article 29, Article 30. GASB 45 Post-Employment Benefits Fund. To see if the town will vote to raise and appropriate or transfer from available funds the sum of $170,000 to meet the town's obligations under the Government Accounting Standards Board, GASB, Statement 45, to fund the town's future obligations for the cost of other post-employment benefits, or take any action thereon or in relation thereto.
Mr. Moderator,
Mr. Hillman.
I move that the town vote to raise and appropriate the sum of $70,000 and transfer from free cash the sum of $100,000 to meet the sum as outlined in the warrant.
Been moved and seconded. Is there any further discussion on it? Okay. There being none, all those in favor, please say aye. Those opposed? The motion is agreed to. Article 31. Excuse me? Actually, he did not. He read the motion the way in the initial read. Article 31, transfer from free cash to UDAG fund. To see if the town will vote to transfer the amount of $550,000 from free cash for the repayment of the UDAG fund for the Neshoba Valley Regional Vocational Technical School membership buy-in, or take any action thereon or in relation thereto.
Mr. Moderator,
Ms. Livingston.
I move the town vote to transfer the amount of $550,000 from free cash for the repayment of the UDAG fund for the Neshoba Valley Regional Vocational Technical School membership buy-in as laid out in the warrant.
It's been moved and seconded. Is there any discussion? There being none, all those in favor, please say aye. Aye. Opposed? The ayes have it. The motion is agreed to. Article 32, Stabilization Fund. To see if the town will vote to raise and appropriate or transfer from available funds the sum of $234,427 or such other funds, sums of money with $210,985 to be credited to the Stabilization Fund under the provisions of Chapter 40, Section 5B of the General Laws, and $23,442 to be credited to the Capital Stabilization Fund per the town's financial policies, or take any action thereon or in relation thereto.
Sorry. Article 33.
32.
How come,
You're ahead of us, Gary.
I thought you were on it? Okay, sorry. Move the town vote to raise and appropriate the sum of $134,427 and transfer from free cash the sum of $100,000 for a total sum of $234,427 with $210,985 to be credited to the Stabilization Fund under the Chapter 40, Section 5B, and outlined in the remainder mentioned by the moderator.
Is there any discussion? All those in favor, please say aye. Aye. Opposed? In the opinion of the moderator, two-thirds having voted in the affirmative, the motion is agreed to. Community Preservation Act articles. Article 33, to see if the town will vote to hear and act on the report of the Community Preservation Committee on the fiscal year 2014 Community Preservation Committee budget and appropriate from the estimated fiscal year 2014 Community Preservation Fund revenues a sum of money equal to 5% and not to exceed $5,000 to meet the administrative expenses and all other necessary and proper expenses for the Community Preservation Committee for fiscal year 2014, and further, to reserve for future appropriation from the estimated fiscal year 2014 Community Preservation Fund revenues the following sums of money as recommended by the Community Preservation Committee for each of the following purposes. A sum of money equal to $111,435, more or less, for acquisition, creation, and preservation of open space excluding land for recreational use, and a sum of money equal to $40,718, more or less, for acquisition, preservation, restoration, and rehabilitation of historic resources, and a sum of money equal to $40,718, more or less, for acquisition, creation, preservation, and support of community housing, or take any action thereon or in relation thereto.
Mr. Moderator.
Mr. Luca.
I move the town hear and act on a report from Community Preservation Committee on the fiscal 2014 Community Preservation Committee budget and appropriate from the estimated 2014 Community Preservation Fund revenues sum equal to 5%, not to exceed $5,000 to meet administration expenses and all other necessary and proper expenses of the Community Preservation Committee for fiscal year 2014, and further to reserve the future appropriations from the estimated FY 2014 Community Preservation Fund revenues, the following sums of money as recommended by the Community Preservation Committee for each of the following purposes. Sum of money equal to $111,435 for acquisition, creation, preservation of open space, excluding land for recreational use, and a sum of money equal to $40,718 for acquisition, preservation, restoration, and rehabilitation of historic resources, and a sum of money equal to $40,718 for acquisition, creation, and preservation of support of community housing. Not take any action.
It's been moved and seconded. Is there any discussion?
Mr. Moderator?
Mr. Luca.
Yeah, this is a yearly procedure that we do. We can only use $5,000 for administrative, which has to do, we advertise in the paper or we have some other, small, usually we don't even spend $1,000 out of it. And then it goes back into the Community Preservation Fund. And the other three set-asides voted on that by the committee. And those set-asides are what the 1% tax is on people's property and the state's portion that they give us.
Is there any further discussion? There being none, all those in favor, please say aye. Aye. Those opposed? The ayes have it. The motion is agreed to. Article 34, transfer of funds, revision of the town's 5-year open space and recreation plan. To see if the town will vote to transfer from Community Preservation Fund open space account fiscal year 2014 estimated annual revenues the sum of $30,000 more or less for review and revision of the town's 5-year open space and recreation plan, or take any action thereon or in relation thereto.
Mr. Moderator.
Mr. Luca.
I move that the town vote to transfer from Community Preservation Fund open space account the sum of $30,000 for a review and revision of the town's 5-year open space and recreation plan, or take any action thereon in relation thereto.
been moved and seconded. Is there any further discussion?
Mr. Moderator,
Mr. Luca?
I'll yield to Mr. Gugino.
Good.
Mr. Moderator, I'm on the CPC Committee, Jessica Gino of Mountain View Avenue. We had voted on April 2nd to ask for a rewording of this article, which did not come through in the warrant. So I'd like to propose a friendly amendment to see if the town will vote to transfer from Community Preservation Fund FY 2014 estimated annual revenues the sum of $30,000 more or less, and reserve said fund for future appropriation by the Community Preservation Act Committee for general open space and recreation purposes, including revisions to the town's open space and recreation plan and expenses associated with due diligence for open space acquisition, or take any action thereon or in relation thereto.
That's what I ask. Excuse me, you do have that in writing, please?
I actually do.
Because we both have to read it.
Yes.
Mr. Pomprian?
Mr. Moderator, through you to the town meeting, to the Ms. Guarino's proposed amendment for Article 34, respectfully, that article that you have, the amended, was originally submitted for the warrant's production. However, upon review of that article and the review of town council, it was recommended by town council as well as the Board of Selectmen that Article 34 appear as it does in the warrant. I understand the intent of the original warrant original article from the CPC, but under Mass General Law, this is the mechanism that needs to be used for that, and town council can correct me if I'm wrong through you, or if he has anything to add through you.
Okay. Town council is saying that this is not in order, according to Mass General laws, and I have no knowledge to be able to say that he's wrong on this one. So I'm going to have to rule that the motion is out of order at this time.
Okay.
Okay? Now, the discussion comes on the article as written in the warrant. Is there any further discussion? There being none, all those in favor, please say aye. Aye. Those opposed? The ayes have it. The motion is passed. Article 35, CPC reduction in membership. To see if the town will vote to amend Town of Ayer bylaws, Article 46, Community Preservation Committee, Chapter 1, establishment to reduce the membership of the Community Preservation Committee from 9 members to 7 by deleting the following language therefrom. 1 member from the Advisory Committee, 2 years. 1 member from the Board of Selectmen, 1 year. Provided further that upon the effective date of this amendment, the terms of the members holding the appointments deleted hereby shall be terminated, or take any action thereon or in relation thereto.
Mr. Moderator,
Mr. Luca.
I move that the town vote to amend the Town of Ayer bylaws, Article, what is it?
46.
Okay, 46, Community Preservation Committee, Chapter 1, as stated by the moderator.
It's been moved and seconded. Is there any discussion on the article?
Mr. Moderator,
Mr. Luca.
this has been discussion for over a year. We've talked about, we've had a problem making quorum at times. I've been on the CPC for the last 6 years. We still have another member at large opening. This would bring it down to 7 members, and it would make it easy to have a quorum of 4 instead of 5. I don't want to speak for the Finance Committee, but the Finance Committee member on the CPC also voted to reduce this. Our board approved the change, so I think moving forward, we should approve this article.
Is there any further discussion? There being none, all those in favor say aye. Aye. Those opposed? The ayes have it. The motion is passed. Article 36, Town Anti-Littering Bylaw. To see if the town will vote to adopt the following anti-littering bylaw under the provisions of Massachusetts General Laws, Chapter 40, Section 21, as follows. Whoever disposes of garbage, trash, refuse, bottles, cans, containers, rubbish, or other debris on a public or private way, or within 20 yards thereof, or in inland waters, or on private property without the written permission of the owner, except in a designated waste receptacle or as may otherwise be directed by the town or the property owner, shall be punished by a fine of $300. Enforcement. This bylaw shall be enforced by any available means in law or equity, including but not limited to enforcement by non-criminal disposition pursuant to General Laws, Chapter 40, Section 21D. The enforcement authority shall be the Ayer Police Department, including any police officer in said department, and the Ayer Board of Health. Each day a violation exists shall constitute a separate offense, or take any action thereon or in relation thereto.
Mr. Moderator.
Ms. Conley.
I move the town vote to adopt the anti-littering bylaw under the provisions of Massachusetts General Law, Chapter 40, Section 21, as read by the moderator and as included in the warrant.
It's been moved and seconded. Is there any discussion?
Mr. Moderator.
Ms. Conley.
For a number of months, we've had residents before the Board of Selectmen asking what the town could do with a number of properties. This bylaw does not speak to those properties in particular, but more to the fact that as you drive through town, you see litter on the sides of the roads. Every April, the recycling committee has a cleanup day, and a week later, you'd never known they were there. The police chief said he needed something with a little more teeth, so the board researched and gleaned from various neighboring towns their bylaws, asked town council for input, and this is the simplest, we think the most effective bylaw that we can have on the books, which will give the police department and the Board of Health a little more strength and enforcement ability so that we can, with any luck, stop the littering that just permeates the town.
Is there any further discussion? Mr. Maxon.
Mr. Moderator, I'd like to speak to the following three bylaws as a package because what I have to say is roughly similar for each one and save the trouble of going through it over and over again. These three bylaws were put on the warrant at the very last minute of the very last meeting we had before we had to send the warrant to the printers, which means we had no chance whatever to review what we were putting on the warrant. I accepted at face value the statement that these bylaws addressed issues that were very important to a lot of people so that it was worthwhile overruling our general practice of doing bylaws in the fall and keeping this Springtown meeting reserved for financial matters. So I voted to put the bylaws on the warrant. But then when I read them, I was very startled. I presumed that the issue about which, and Ms. Conley just referred to, that a lot of people were concerned was the appearance of properties in town. And there's nothing in this package of bylaws to address that at all. The anti-littering bylaw, ironically enough, on my way home last night, a half a block from my house, there was litter on the road that hadn't been there on my way to the town meeting. But this bylaw would have had nothing at all to deal with that because there was nobody there to see, observe, putting the litter down. So I think that certainly we've gotten along without a littering bylaw, anti-littering bylaw until now. We can survive until fall town meeting instead of considering it to be an emergency. The next one is an unregistered cars and unregistered vehicles bylaw. We have an unregistered vehicles bylaw that corresponds to state law about unregistered vehicles. It seems to serve the town well. I haven't heard any chorus of complaints about unregistered vehicles in town. And if we're going to pass another bylaw, wouldn't it be prudent to have a companion article to rescind the old bylaw? We'll have two bylaws that are confusing, and I think this shows that this was not thought through properly before we put these on the warrant. And the third is the bylaw that multiplies the penalties for offenses. Well, we have a bylaw in effect right now that specifies what those penalties are. And I haven't heard that there's been a lot of complaint that those penalties aren't high enough, but certainly that has served us well enough that we don't need to consider it an emergency to increase the penalties at this meeting. We can go to, by our usual standards and usual practice of doing it at fall town meeting. And again, if we pass this one, we'll have two bylaws in effect, adding on only to the confusion. Again, another indication that This was not thought through properly before these were added to the bylaw, to the warrant. So, Mr. Moderator, I would move, in the interest of doing things right, that we table Articles 36, 37, and 38 and go home. We can deal with these matters much more effectively, much more appropriately, and with due diligence in the fall.
Mr. Luca, what is your point of order?
We already have a motion on the floor.
Actually, a motion to table supersedes the motion on the floor. Moved in, okay, and Mr. Maxent, I wasn't quite finished with you yet. I'm going to ask you to make 3 separate motions when each one comes to the floor. Okay? So right now, you're moving to table Article 36, and it's been seconded, correct?
That's what I understand, yes.
Okay. Okay. All those in favor of tabling Article 36, please say aye. Aye. Those opposed, please say no. No. In the opinion of the moderator, the noes have it. The motion to table is set aside. Is there any further discussion on the main article? Yes, sir.
Mr. Moderator, Chuck Frisbee from 84 Groton School Road. I basically concur with this other gentleman's saying on all 3 of these articles. I'm relatively new to the town, so I apologize if I misspeak here, but basically one of the things I see in the first article is that there is nothing specified as to how this would be administrated to somebody that would be in violation and what their due process would be to fight it. If I can, I'd also like to just consolidate my comments for the 3 articles.
Very well.
Because Article 37, on its face, is also contradictory. Section 2 is contradictory with Section 5E. In Section 2, it says no more than 1 registered vehicle. And then in Section E, it says that the selectmen may waive the public hearing on allowing that single vehicle to be there. When, if I understand the article correctly, that 1 vehicle is allowed, unregistered. If you wanted any more than that, you have to have a waiver or some other process to go through. So those 2 on its face are contradictory. And the enforcement law, just like the gentleman said, that it doesn't appear to be well thought out, and my statement again is a process of due process. How do I get administrated a fine? You know, how do I wind up fighting if I feel unjustified for being administrated on those 3 articles? Thank you.
You're welcome.
Mr. Moderator?
Mr. Hillman.
The purpose of these articles was to try to eliminate some of the garbage that's thrown on the side of the roads. Despite Mr. Maxon's objections to this, I just cannot see why anybody wants trash on the side of their roads. Albeit, the chances of the police department catching someone throwing trash on the side of the roads is probably 1 in 100, but it happens. And if there's a deterrent, if there's a couple signs posted out throughout town, I know other towns are very, very diligent in enforcing it, and they have seen a dramatic decrease in litter. I can't speak for all of you, but it drives me crazy when I drive up Sandy Pond Road and Westford Road and just see people who I hope are not from this town who stop at McDonald's and Dunkin' Donuts and decide that, wow, there's no houses here. Let's throw the trash on the side of the road. This article was designed to help Chief Murray and his staff have the right procedures to find these people. And I may ask the chief to speak on this, but as I understand it now, it's a more of a drawn-out process in order to actually get a fine and whatnot, Chief? So this would kind of give it back to the chief in their discretion on whether they can give a fine to an individual if they catch them throwing or illegally dumping, as opposed to going to the court system and tying up our officers and whatnot. We can do this on a local level, much quicker, faster, and get the word out that we're not going to tolerate litter on our roads. It's a huge cost for the town. Like Ms. Conley said, we do the litter cleanup day, and it looks great until about Saturday afternoon or Saturday evening, and the people just do it over and over again. So I'm baffled that this wouldn't be supported. But thank you.
Is there any further discussion on Article 36? There being none, all those in favor, please say aye. Aye. Those opposed? No. The ayes have it. Motion is agreed to. Okay. Article 37, unregistered vehicle bylaw. To see if the town will vote to adopt the following unregistered vehicle bylaw. 1. Definitions. For the purposes of this article, the following terms shall have the meanings indicated. Inoperable vehicle. Any motor vehicle as defined in Massachusetts General Laws, Chapter 90, Section 1, that is not capable of being used as such in its existing condition by reason of being worn out, damaged, or dismantled, or failing to contain parts necessary for operation, and which is ready for dismantling or destruction, or which has been collected or stored for salvage or for stripping in order to make use of parts thereof, or any collection of parts from such vehicle. Unregistered vehicle. Any motor vehicle that is not registered in accordance with Massachusetts General Laws, Chapter 90, Section 2. 2. License required. No more than one unregistered or inoperable vehicle shall be kept in any area of the town of Ayer by the owner of the vehicle, or by the owner of one, or one in control of the premises wherein such vehicle is kept, unless a license has been granted in accordance with the procedures hereinafter described. 3. Enclosed vehicles exempted. Motor vehicles, including unregistered or inoperable vehicles, kept in an enclosed building shall not be subject to the provisions of this article so long as they remain enclosed within a building. If more than one motor vehicle is taken outside of a building, it shall be subject to the provisions of this article. 4. Exempt businesses. Any business which has a Class 1, 2, or 3 license for the sale of motor vehicles under the provisions of Mass General Laws, Chapter 140, Section 58, as amended, shall be exempt from the provisions of this article. This article shall not apply to motor vehicles on property where the principal business use is a farm, garden, or nursery, provided that such motor vehicle is necessary for the operation of such business. 5. License for keeping of unregistered or inoperable vehicles. A license to keep more than one unregistered or inoperable vehicle may be requested by filing an application in writing with the Board of Selectmen. The Board of Selectmen shall hold a public hearing upon such a request. Notice of the public hearing shall be provided by publication in a newspaper having a general circulation in Ayer at least 7 days before the date of the hearing, and notification to all abutters within 300 feet of any part of the storage property via certified letter with a return receipt at least 7 days prior to the date of the public hearing. Said return receipts shall be provided to the Board of Selectmen or its designee at the time of the public hearing. Failure to provide return receipts may be grounds for disapproval of the application for storage. All costs of publication and notice to abutters shall be paid by the applicant for the license. The applicant shall be responsible for actually publishing the notice and sending it to all abutters as outlined herein. C. The Board of Selectmen may grant a license for a period of no longer than 1 year upon such conditions as the Selectmen deem proper to allow unregistered or inoperable vehicles to be kept in the open after public hearing has been held and the Selectmen determine that the keeping of same will not create a hazard to the public safety or will not become a public nuisance, and that no unsightly conditions visible from public streets or ways or abutting properties exist or will be created. Renewals of such said license may be granted at the discretion of the Board of Selectmen, subject to compliance with the public hearing procedure established herein. Upon the filing with the Board of Selectmen of a petition signed by at least 10 registered voters of the town of Ayer requesting revocation of any license issued under this article, the Selectmen shall hold a public hearing to review the conduct of the licensee under said license. If the Selectmen determine that the operation of the licensee under such license is such as to create a hazard to the public safety or to constitute a public nuisance, or that unsightly conditions visible from public streets or ways or abutting properties exist, the selectmen, by a majority vote, may revoke said license. The effective date of such revocation shall be 30 days after said vote of revocation. E, the selectmen may waive the public hearing requirement to allow the keeping of one unregistered or inoperable vehicle on the property owner's premises for a period of 14 days or less if it finds that no hazards or health or safety are involved, and no unsightly conditions visible from public streets or ways or abutting properties exist, or will be created by the storage of said vehicles for such temporary period of time. 6, enforcement and penalty. This bylaw shall be enforced by any available means in law or equity, including but not limited to enforcement by non-criminal disposition pursuant to Massachusetts General Laws, Chapter 40, Section 21D. The penalty for violation of this article shall be punished by a fine of $300. The enforcement authority shall be the Ayer Police Department and/or the Ayer Building Commissioner. Each day a violation exists shall constitute a separate offense, or take any action thereon or in relation thereto.
Mr. Moderator,
Mr. Hillman.
I move that the town vote to adopt the following unregistered bylaw as stated by the moderator.
It's been moved and seconded to adopt this bylaw. Is there any discussion?
Mr. Moderator,
Mr. Hillman.
I would like to make an amendment to Section E, and just the wording, please.
Okay.
2 words. The Board of Selectmen may waive the public hearing requirement to allow the keeping of, it says now, one, and I believe it should say keeping of more than one unregistered inoperable vehicles on the property owner's premises. So more than one after the word of.
So moved and seconded to amend the article. Is there any discussion on the amendment? There being none, all those in favor say aye. Aye. Opposed? And any discussion on the article as amended? Yes, sir.
I'd like to appeal to this gentleman and ask if there could also be an amendment to the provision of, and I apologize, I misplaced my place here, within the building. It specifies that if the vehicle is outside the building, then it's subject to this amendment, or this, this article. And it doesn't specify how long. I mean, if happenstance comes, somebody drives the vehicle outside and is the second vehicle that was in the building, then it could be subject to this article. It couldn't be a day, couldn't be a week, couldn't be 10 minutes. Thank you.
Mr. Moderator?
Mr. Hillman.
Just a question for the gentleman. So, sir, you're just looking for more of a timetable, so if you have an unregistered vehicle and you back it out of your garage, you're not going to get a fine in 10 minutes or how long it can stay out of the garage? Is that how I understand?
For the comment I just made, yes, sir. I'm still basically opposing to the article in itself for a few other reasons, but not to belabor the point, that yes, this article is a bit vague in some of the aspects of time frame and what's considered an amenable time to repair a vehicle if it's in your yard to be done so. I mean, I apologize, but I'm a mechanic for 30-some-odd years and 40 years. I'm also an engineer, so at times I fix my own vehicle or 2 or 3 of my own vehicles, and not being my primary job, it takes me a little while to get around to doing it, but I do finish up and get rid of them. So that's another reason why I'm a little bristled at this particular article. Thank you.
Thank you.
Is there any, so you're making, what is your motion, sir?
I apologize. I don't exactly have a motion, but pursuant to what he's asking, if that is one of the things that I'm contending here is, yes, there is no time frame in the covered unregistered vehicle, by this article.
Okay.
It could be out 2 minutes and
So you're not
be a
actually making a
fine.
motion, you're asking them to make, amend, you're
If
asking
that's
them to
possible,
amend it.
yes.
Mr. Moderator, excuse me.
Mr. Hillman?
I understand what the gentleman is saying, but my concern is that we're going to get, it's only been there for a day or 10 minutes, or I would think that knowing our police department and working with them, that if this gentleman's out changing his oil in his classic car, I can't imagine there's going to be any issues whatsoever. I believe this article, at least how I perceive it, is to junk vehicles that are just left and whatnot, not so much your classic car or bike or whatever you have, sir. But I just feel that if we amend this and allow that language in, we're kind of opening up a whole can of worms for when someone does call and complain and the person says, well, I've only had it out here for 3 days and I get 2 weeks. I just think that's just a way too wide range of wording. I think it should be up to the discretion of our police department if they feel that it is necessary to address, or maybe, sir, you should move this vehicle within the next week or two, in my opinion. Thank you.
Yes, sir.
Under those comments, then, what I would recommend and I would like to suggest is that the definition be amended at the beginning of this, where an unregistered immovable vehicle by whatever the definition there, and say once notice has been given, it's something to the effect of like a week or 2 weeks from that point. That way it gives that person an opportunity to remove the vehicle, it gives a small time frame, and it's not something that's there repeatedly, versus somebody who may not be pleased by the fact that there's a vehicle out there for 5 minutes rather than allowing somebody to get work done or get it moved.
Mr. Moderator,
Mr. Hillman?
may I ask Attorney Corbo to address this issue, please?
Town Council, Greg Corbo?
Thank you. Through you, Mr. Moderator. Yeah, I'd like to address a couple of concerns that were just raised by the gentleman, and also to explain why this particular bylaw is different than the bylaw that is already in place. And it's different in several significant respects. Sort of working backwards, a concern has been raised as to the ability of a person to temporarily have unregistered or inoperable vehicles on their property without having to go through the public hearing process that's set forth in the bylaw. And if you look at section 5E, what it says is that the Board of Selectmen can waive the public hearing requirement and allow the keeping of more than one unregistered or inoperable vehicle on property for a period of 14 days or less if it finds that no hazards to health or safety are involved and no unsightly conditions visible from public streets or ways or abutting properties exist or will be created. So what the purpose of this is to address the very situation where somebody has an inoperable vehicle on their property and it's intended to be there for a short period of time, whether it's to do some work on it or to store it for a particular purpose. They can come to the Board of Selectmen in a more informal way, put the Board of Selectmen on notice that it's going to be there, and the Board of Selectmen can make a finding that it's not constituting a nuisance, and it can be allowed for that short period of time. Of course, as with any bylaw, the police department has enforcement discretion, and if the police department finds that it's appropriate to give somebody a warning, you've got to remove these vehicles within a certain amount of time, that's always within the inherent discretion of the police department to do. Ways in which this bylaw is different than the bylaw that's already on the books, there are several ways. First of all, this bylaw prohibits a broader class of materials from being stored on property. The bylaw that's in place now references unregistered vehicles. The term unregistered vehicles in the current bylaw, however, is not defined. The new bylaw not only defines what constitutes an unregistered vehicle, but it also broadens the scope to inoperable vehicles, which are vehicles that are not in working order, but which nonetheless may be registered. And it also significantly prohibits the collection of parts from such a vehicle. So what this is designed to get at is, properties that have large accumulations of car parts scattered around in a manner that constitutes a public nuisance. So in that way, this bylaw is broader in that it covers more materials are prohibited under this bylaw than are prohibited under the existing. The second way in which it's different is that it defines the period of time that the selectmen can grant permission to keep these materials on property. The current bylaw says that a permit can include a reasonable time limit, but not longer than a period of 5 years. Well, the new bylaw now comes in and defines what that reasonable time period is, and it specifically says that it's 1 year subject to renewal by the Board of Selectmen. In addition, the new bylaw expands the enforcement authority of the town. Under the existing bylaw, only the building commissioner can take enforcement action with respect to unregistered vehicles. Under the new bylaw, enforcement authority lies not only in the building commissioner, but in the police department as well. And finally, the new bylaw provides for increased penalties and broader enforcement authority on behalf of the police department and the building commissioner. Thank you, Mr. Moderator.
Thank you. Is there any further discussion on the motion as amended? Mr. Resigay. Yes.
Just a quick question here on number 3, the enclosed vehicle exemption, and it talks about, an enclosed building. Is there a definition of this, with the number of, quote, temporary buildings that you can pop up on your property in very short time now? Can somebody who potentially has 5 cars that we're concerned about pop up 5 of these quick shelters and say, I now have an enclosed building? Do we have a definition? I don't know if that's in our zoning or not.
Mr. Moderator?
Ms. Connolly.
Mr. Resigay, yes, the zoning bylaws do regulate how many pop-up buildings you can actually put on there, where you can put them, and so on, without running into violation of the zoning bylaw. So that would be predominantly the responsibility of the building commissioner and abutters to file a complaint. But the zoning bylaw specifies what appurtenant buildings can be put on a residential property and on a commercial property, and it differs depending on where in town those properties are.
Does one presently have to pull a permit to put up a temporary storage unit you see cars stored in?
Mr. Moderator, I don't have my zoning bylaw book with me, Mr. Resigay, but most likely I would think any structure that's going to be there for any length of time that isn't permitted by right certainly would need a permit from the building commissioner. He will issue the permit if it's in compliance with the zoning bylaw. If it is not, then the applicant can seek a variance from the zoning board of appeals. So there is a process by which it would need approval.
That would be my only thought or concern. Whereas I've heard many people say, and I don't know how valid it is, that these are, quote, temporary structures, and for that reason get around a lot of the, zoning bylaws or rules or regulations that are out there presently. So potentially, is this a loophole?
Any further discussion?
All right, Mr. Moderator.
Mr. Maxon.
Mr. Corbo's description of the bylaw made it sound to me like it's a solution looking for a problem. I don't know that we've had any problem with all of these other things he's talking about in town. I don't know that we had any problem with unregistered vehicles to the extent that we should do it in such haste. So rather than move to table, I will simply ask the Assembly to vote this no, and we can deal with the issue in the fall town meeting, and it's ordinary time for this sort of thing, and with a lot more discussion and resolution of the issues people are bringing up now.
Is there any further discussion? There being none, all those in favor, please say aye. Aye. Those opposed, please say no. No. Ms. Connolly, questions of vote. Could I please have Mr. Swanfeld and Mr. Kelly, would you be able to help us count? Thank you. Will all those in favor please stand and raise your blue or purple card? Yes. Will all those opposed please stand and raise your blue or purple card? "25 have been voted in the affirmative, 21 in the negative. The bylaw is adopted." Keep going. Article 38. Mr. Pattington.
Just based on the vote, which comes to 46, I appreciate some people may not have voted, but question the quorum.
Mr. Pattington doubts the presence of a quorum. Can I please have my counters? And please ask everyone who's a registered voter to please stand so they can count you, including the stage. I didn't vote in that last one, did you? No, I didn't vote in that last one, did you? No. There are 52 people present, 50 is needed for quorum, therefore we will continue. You're welcome. Article 38, Enforcement Bylaw. To see if the town will vote to adopt the following bylaw regarding enforcement of the town's bylaws. 1. Enforcement through indictment or on complaint to district court. Any bylaw, rule, or regulation of the town of Ayer duly adopted and enforced may be enforced through any lawful means in law or in equity, including but not limited to enforcement by criminal indictment or on complaint before the district court pursuant to General Laws, Chapter 40, Section 21. Each day that a violation exists shall constitute a separate offense. A fine of up to $300 may be imposed for each violation. 2, non-criminal disposition. Any bylaw, rule, or regulation of the Town of Ayer, its officers, boards, or departments duly adopted and enforced, the violation of which is subject to a specific penalty, may, in the discretion of the town official who is the appropriate enforcing person, be enforced in the method provided in Section 21D of Chapter 40 of the Massachusetts General Laws. The specific penalty for purposes of non-criminal disposition for each such violation, if not otherwise specified, shall be $300.
Mr. Moderator,
Ms. Connolly.
I move the town vote to adopt the bylaw as, the enforcement bylaw as read by the moderator and included in the warrant.
It's been moved and seconded. Is there any discussion?
We missed a page?
You didn't turn the page.
Hold it.
Oh, Mr. Moderator, you failed to read part of the warrant, the article.
Ms. Connolly, the copy you gave me did not have it on there.
Well, I didn't give it to you. It's not in the warrant either.
I'm sorry.
The copy's not in the warrant either. It's only a three-part.
Okay, here he goes. Enforcement authority. The enforcement authority hereunder, in addition to any officer or authorized person specified in any particular bylaw or rule or regulation of the town, shall be the Ayer Police Department, including any police officer in said department. In addition, the following officers may enforce the following bylaws: anti-littering bylaw, Board of Health, Building Inspector; nuisance bylaw, Building Inspector, Ayer Board of Health; wetlands, Conservation Commission; unregistered vehicle bylaw, Police Department, Building Commissioner, or take any action thereon or in relation thereto.
Thank you, Jessica and Julie. I didn't turn the page like you guys did, but now I move that the town approve adopt the enforcement bylaw as read by the moderator and included in the warrant.
Is there any further discussion?
Mr. Moderator, this
Ms. Connolly.
This bylaw applies to the enforcement of all adopted bylaws in the town of Ayer as outlined in paragraph 3 by the individual enforcing authorities.
Yes, sir.
Moderator, I apologize if I, with respect, that I think this is a little disingenuous to have this particular rule, this article after the other two were just passed with the premise that it gives Ayer the ability to have an alternative enforcement ability other than the courts, and now this particular article is specifically saying that they can immediately go right to the courts.
Ms. Connolly.
Mr. Moderator, I believe I'm going to defer to Mr. Corbo, but to give at least my interpretation of the answer to this, the people or the authority that would go to court is the town of Ayer, through those entities listed on paragraph 3. And in order for the preceding articles or bylaws to apply, or this to apply to them, they had to be previously adopted. So the procedure is the way it is, and trust me, we had town council put this together for us because we're no experts at it either. And on that, Mr. Corbo, if you would like to share your thoughts, I would encourage us to let him do so.
Thank you. Through you, Mr. Moderator.
Mr. Corbo.
Generally speaking, prior to this bylaw being enacted, if it is, there are two ways in which local bylaws can be enforced by town officials. The first way is to pursue criminal action by filing a criminal complaint in the district court and seeking the assessment of fines or, in some cases, imprisonment. The second way is for town officials to initiate civil enforcement through the courts, which is to ask the courts to order that persons come into compliance. This first paragraph simply sets forth those two general ways of enforcing town bylaws. with or without that first section, those are the choices that the town has to enforce town bylaws. The second provision, non-criminal disposition, creates something new here in Ayer, although in common practice in the Commonwealth. And what it does is it allows town officials to enforce in a less formal way by issuing a ticket. And so rather than having to take someone to court in the first instance, a town official can issue a ticket. The ticket is payable within a certain period of time, and if the ticket is paid, then that individual is not subject to criminal penalties. It's only if the person does not pay the fines that criminal penalties are triggered. So what this bylaw is proposing to do is to add this third mechanism of enforcement to allow for more informal enforcement at the local level in the hopes that taking people to court does not become necessary. Thank you, Mr. Moderator.
Thank you, Mr. Corbo. Is there any further discussion? Mr. Maxon.
In addition to what Mr. Corbo just mentioned, this bylaw would also increase dramatically the level of the fines being imposed. And I believe this would then change dramatically the relationship of our town government to our citizens from one of reasonable cooperation and encouragement to one of rule by severe and very severe means. And I think that we do not want to make this sort of change without a lot of forethought. And again, this bylaw does not have a companion article to rescind the other bylaw. We'd have two on the books. I believe again, as I believe for the others, that we should postpone this action on this until the fall town meeting by voting no on it now.
Is there any further discussion? Yes.
I'm Julie Carnswick, and my question is, if somebody wishes to dispute one of these tickets, do they just go to court and dispute it, like for a traffic ticket?
Mr. Moderator.
Ms. Connolly.
Julie, yes, the answer from Mr. Corbo is saying yes, that would be the process like any other ticket.
Ruth Maxon, Schultz, Taft Street. Mr. Moderator?
Ms. Schultz.
So if I understand this correctly, then, it means that on number three, the enforcing authority, that anyone on the Board of Health or the building inspector or the conservation, anyone on the conservation could issue a ticket, and this fine could be $300 every day. They could issue another ticket. So am I correct when it says the enforcing authorities, and that all these people listed could actually be the ones that do this?
Mr. Moderator.
Ms. Connolly.
Ms. Schultz, the Conservation Commission can only issue a ticket or fine for violations of the wetlands bylaw, not for just anything. The Board of Health and building inspector for the anti-littering bylaw. There are other things, as I'm sure you know, under the purview of the Board of Health, but as far as this enforcement bylaw, their jurisdiction is the anti-littering bylaw, and if you read the next line, also the nuisance bylaw. And as far as the unregistered vehicles bylaw, the enforcing authorities are the police department and the building commissioner.
My question would it be done as an individual, or is it as a committee then? Does it have to be a committee action, or just could one of the individuals go and say, I'm on the Board of Health, I'm going to give you a ticket? I don't know what is this doesn't seem too specific here.
Mr. Moderator.
Ms. Connolly.
The Conservation Commission has a conservation agent working for them, an administrative person. I know other members of the Conservation Commission have also issued citations, I think is what they call. They have different words for the violation forms that the Conservation Commission issues. The building inspector is an individual, not a committee. The Board of Health is an elected board. I would expect that if one of the members of the Board of Health saw a violation, they would be empowered to give notice to the violator. The police department is 18 to 20 individuals. I keep losing count. And That covers all of the enforcing authorities listed here. So you want to know whether they actually have to vote at a public meeting to issue a violation? Is that your question?
Yes.
Well, you have two groups that have open meeting law regulations, the Board of Health and the Conservation Commission. And they are empowered as individuals to enact this bylaw, or to enforce this bylaw, once this bylaw is adopted. But there are appeals processes for those people who are cited, as we explained in answer to Julie's question.
Okay. All right. Thank you.
Jessica Gino on the Conservation Commission. As a general rule, we don't issue violation notices individually. Our agent may issue one, but then we discuss it in public meeting and vote as a group to ratify it. So we don't act individually in that respect. In addition, the wetlands bylaw, we had not asked for this article, but we're quite pleased to see this because it does give us a little more teeth to enforce violations of the wetlands bylaw. In addition, I've heard in towns like Groton, what commissions will often do is issue a fine for a violation, and then if somebody, did something out of complete ignorance and no malevolent intent, they cancel the fine if there's quick compliance. So it doesn't seem to me that it automatically puts in a negative relationship between commissions and boards and residents.
Mr. Moderator?
Mr. Hillman.
Unless you're breaking the law, this really doesn't apply, but the way I look at it is it gives our police department the means to warn the individual, but then also fine them and not tie up Chief Murray's department and the citizen in a long, belabored court process that may last a year, where the individual may have to hire an attorney. The chief may have to tie up an officer for 6 or 7 or 8 court appearances. It just really, I think, gives the enforcing agents a much streamlined way to communicate with the individual and try to rectify the problem before we get to the court system, and then now we're costing the town money, we're costing the individual money, and that's honestly not fair to either one. Our police department is very fair. I mean, warnings, I'm sure, will be issued to rectify the problems, but like I said, I think this is a much streamlined way to get to the same result that doesn't take 4 or 5 years when people in the department may change, attitudes may change. Sometimes you just get worn out, and I've seen these instances where homeowners end up almost bankrupt because they're fighting. Maybe we can come to a solution on a local level that solves the problem within a week or 2, as opposed to dealing with something for 2 years. Thank you, Mr. Moderator.
Mr. Resinger.
Mr. Moderator, I'm just a little confused here in that, thinking of the Board of Health as one, does this authority to issue citations that extend to their agent, the Neshoba Associated Boards of Health, the agents from there? The other thing I'm confused about is it sounds as though the Conservation Committee has an agent that goes out that would have the ability to issue this citation, but then the Conservation Committee is saying when this has happened in the past, it's come back to them and they've talked about it and decide to go forward or not. But with this bylaw in place and what town council is indicating that this would be resolved in the courts if a person chose not to pay the fine, I mean, once a citation is issued by one of these agents, can it then go back to a board to be reviewed? I'm confused. This is seeming very muddy to me.
Well, Jessica Gino again.
Gino.
Currently, and George, you can correct me if I say anything wrong. Currently, the only power we have in conservation is if any one member or our agent sees a violation, we can issue a violation notice, which is basically a warning. that ask somebody to come in and talk to us. In order to proceed to another level, the next step would be an enforcement order, which would then be sent to the state, to Mass DEP. For that, we have to decide as a group, and we have to ratify that by a vote in public meeting. But we have no teeth to that measure as well. It's just reporting it to the state. The state has limited resources. If they decide to pursue something, they have the ability to impose very large fines or other actions, but we don't have any ability. But just to reassure, our current thing is we wouldn't be acting, cowboy style, going out and issuing tickets and thus. We would probably still, and we haven't discussed this, but we probably would still follow our similar procedure now of issuing violation notices, asking residents to come talk to us so we can explain the Wetlands Protection Act and what they've done wrong, make suggestions for how they could rectify a situation or do it better. If violations keep happening, then we would move to the step of an enforcement order. This would give us the ability to have that actually mean something without having to go to the state.
Mr. Rezaje.
Mr. Moderator, again, I appreciate what the Conservation Committee is saying is in place now, but this changes that. That was then and this is now. So I'm just wondering, are things going to get a little muddy here? We're putting a bylaw into place potentially this evening that's going to grant authority to these agents or these different boards within the town and agents of the town. And it doesn't sound as though these boards, this has been brought to them to discuss with them, this is how we see as a town it should be put forward. Don't get me wrong, I don't think this is a bad idea. I'm just wondering if we don't have the cart before the horse here.
Mr. Moderator?
Mr. Luca?
I understand what you're saying, Rick. We had some discussion in one of the meetings that if any of these boards or committees or commissions, want to talk to the chief of police, saying this is the issue that's going on, can you go investigate it? That may be a good way to keep it, but there's more eyes on the problem. But we have one person maybe controlling it. That was some of the discussion we had. I want to hear from town council on this, please.
Mr. Corbo?
Thank you. Thank you. Hello? Hello? Thank you. Through you, Mr. Moderator. Yeah, it's important to understand that there's nothing about this bylaw that changes the discretion of town officials to work with property owners to achieve a resolution. And really nothing about this changes the substantive nature of the interactions between the town and its residents. As things stand right now, all of the bodies mentioned in this bylaw have significant enforcement authority and the significant capability to, invoke their powers to compel compliance. They also, though, have discretion as to how to exercise that power. And that discretion includes working with property owners to try to informally resolve things before they get to a formal enforcement position. What this bylaw does is it just adds another layer of informality before things have to get ratcheted up to go to the court. It doesn't change the discretion of any town official to work with someone and not take enforcement action or to give them leeway in order to come into compliance. Even once a ticket is issued, say by the conservation agent or the health agent, nothing prevents the property owner from going to the Board of Health or the Conservation Commission and asking for a vote of the board to nullify or amend that order. All of those things that are in place now will still be in place. The only thing that's different is now there's this sort of additional mechanism that allows town officials to issue tickets if more informal means are not successful in resolving the problem. Thank you, Mr. Moderator.
Is there a second? Okay, there's a motion to move the question. All those in favor of moving the question, please please say aye. Aye. All those opposed? I'm going to question the vote myself. The motion to move the question requires a two-thirds vote. Can I please have my counters come down, please? All those in favor of moving the question, please stand and raise your red or blue, purple card. Yes. Those opposed to moving the question, please stand. In the affirmative, 35. In the negative, 12. That's two-thirds vote. The motion is moved. All those in favor of passing the amendment as written, please say aye. Aye. Those opposed, please say no. No. Could I have my counters come down, please? I question the vote myself. All in favor, please stand and raise your blue or purple card. Well, all those opposed to the new bylaw, please stand and raise a blue or purple card. Those voting in the affirmative, 31, and the negative, 19. The bylaw is adopted. Mr. Swanfeld.
Mr. Moderator, I get a motion to adjourn this meeting.
All those in favor of adjourning the meeting, please say aye. Aye. All those opposed, say no. I was waiting for that. Have a good night, folks. We're done.